So, good afternoon, everybody, and thank you very much for joining us today. I'm very pleased to see that we have been joined by quite a few people, and thank you very much for your participation. My name is Christiana Markou. I'm an associate professor in law at the European University Cyprus and a project manager at Eunomia Limited. This online workshop is co-organized by 4 EU-funded projects, which you can see on the slide: Pandora, Consentis, Curium, and Synapse. And I'm very pleased to let you know that we have 4 knowledgeable presenters who are ready to enlighten you on several issues that we are sure are of interest to you concerning, of course, the AI Act. I will be presenting the speakers in due course, but I'm sure you saw their names and affiliations on the agenda. Each one of them represents one of the organizing projects. And of course, at the very center of our today's event is a very important and a very complex and technical legislative measure, EU legislative measure, about which there is much discussion recently, the AI Act, of course. And as we move closer to its broader application, everybody affected, including EU-funded projects, are trying to make sense of it. More specifically, they are trying to understand what it means for them in practice, for the development, testing, deployment of AI systems when, of course, these happen, as is often the case, in the context of EU-funded projects. So the very purpose of our today's gathering is to give you an overview of the AI Act and help you understand the basic concepts, rules, requirements, and of course, what that means in practice for project teams. Before we move to the agenda, just a few housekeeping points. Please note that the session is being recorded, so if you are shy or you don't want to appear in the recording, you may want to keep your cameras and microphones off. Also, for more information regarding how your personal data is being processed in the context of this event, of this session, you can have a look at the privacy notice, which have been shared with you with registration. And of course, if you want to share any comments, you are very welcome to do so. Pose any questions, of course, you can do that. Only thing, be sure that you use the Q&A function of the platform, not the chat, because there will be a Q&A session right after the workshop, in the context of which we will be happy to answer any questions you have or hear any comments you may want to share with us. Just to let you know that you can also pose your questions anonymously in the Q&A part of the platform, and I will then raise the question to our presenters, our speakers, who will be happy to answer them. Now, regarding the agenda, I'm not going to walk you through all of it because I'm sure you have seen it and you also have it in front of you. You can see that there are 2 parts, Part A and Part B, in today's workshop. Part A is aims at giving a theoretical background on the AI Act, which is very important for you to follow and understand the more practical information that will be given in the next part. Even in the second part, our presenters have tried to include examples so that it is not purely theoretical, but the background is necessary to help you make the most out of it, of the part B, which is the more practical part of our today's event. So without taking any more of your time, I will give the floor to our first presenter. He is Mr. Nikolaos Kouliarakis. He is a legal consultant and project manager at Eunomia Limited, who is going to start with a high-level introduction to the AI Act and will set the background for all the interesting speeches, presentations that will follow. Nicola, you have the floor.
Okay, thank you very much, Christiana. So, hello everybody from my side. Let me begin with the first presentation with a high-level overview of the EU AI Act that will set the stage for the following presentations. Here, we will try to build a practical understanding of the Act, who it applies to, how its risk-based logic works, and what are the main obligations for providers and deployers. So, let me start with some basic facts. The EU AI Act is the first comprehensive and binding legal framework specifically dedicated to AI globally. And it is important to emphasize that it is a horizontal framework, right? This means that it applies across sectors and it may thus be relevant to a wide range of organizations. It is a very complex law of around 150 pages long that basically regulates how AI is developed, brought to the market, and used in the EU while protecting safety and fundamental rights. A central feature is its risk-based approach. The obligations depend on the type and purpose of the system and the level of risk it may pose. The Act introduces obligations for different actors across the AI value chain, including providers, deployers, importers, and distributors. It was enacted on August 2024, and its requirements apply in phases, with August 2026 as the main milestone for most of the obligations. Just note that at the moment, it is being negotiated whether the application timeline will be postponed so as to allow the finalization of the related harmonized standards, but as of now, the initial timeline hasn't changed. Finally, we should keep in mind that the Act is backed by significant enforcement powers, including potentially very high fines comparative to those under the GDPR. Okay, turning now to the purpose of the EU AI Act. Here, I think it is helpful to understand it first and foremost as a form of product safety legislation. This means it treats AI like a regulated product entering the market through pre-market conformity assessment, CE marking certification, and post-market surveillance. But the twist here is that the notion of safety is extended to incorporate fundamental rights as well. Now, with regards to its stated purpose, the Act explicitly pursues four main objectives. First, it aims to improve the functioning of the internal market by creating a uniform legal framework. So this is in contrast, say, with the US approach, where instead of a single law, we find the patchwork of state-level initiatives. And moreover, the Act is a regulation rather than a directive, right? Which means it is directly applicable across the EU, bringing this element of uniformity and legal certainty. Second, it seeks to promote AI that possesses certain characteristics aligned with EU values, namely, AI that is human-centric and trustworthy. Third, it is designed to ensure a high level of protection of health, safety, and fundamental rights. So we find this strong protective element in the AI Act that extends to incorporate fundamental rights as well. And finally, it also aims to support innovation, particularly for SMEs and startups, through measures including simplified compliance and reporting obligation, regulatory sandboxes, and others. So, putting this together, the goal here is not to hinder innovation, but to create a common and predictable legal framework under which AI can be developed and used in ways that are safe and aligned with EU values. Okay, now, what is the material scope of the EU AI Act? The starting point here is obviously the definition of an AI system, which comprises 7 key elements. So, an AI system is a machine-based system designed to operate with some autonomy that may show adaptiveness after deployment, which, by the way, is not mandatory, and that for given objectives, it infers from input it receives how to generate outputs that can influence physical or virtual environments. Now, I don't want to spend much time here. The Commission has published extensive guidelines that help break this down. I would just like to note that this is a widely accepted definition adopted by the OECD. Second, it is meant to be technology neutral and life cycle based, covering both the building and the use phase. And finally, that the central, most decisive feature is this notion of inference. This is what separates AI systems from ordinary software. The idea here is that the system must not merely execute fixed human-defined rules, it must rather be capable of deriving outputs through techniques such as machine learning, knowledge-based reasoning, etc. So, in practice, not every software will qualify as an AI system. Some examples that may fall outside this definition may include purely descriptive statistics, classical heuristic systems, and prediction systems based on averages. Now, to be clear, the Act also defines and applies to foundation or so-called general-purpose AI models, but those are set aside for now to be specifically addressed by Giovanna later. Let me now briefly touch upon who gets caught by the Act. So, one point to emphasize here is that the regulation is not limited to companies established in the EU. So, as you can see on the right, the AI Act applies to providers placing systems on the EU market or putting them into service, regardless of where those providers are established. It also applies to deployers located in the Union, as well as to providers and deployers outside the EU, where the output of the system is used in the Union. In addition, importers, distributors, and in some cases product manufacturers may also fall within scope. So, the takeaway is that the AI Act introduces obligations across the AI value chain, and like the GDPR, it has a clear extraterritorial dimension. What matters is basically whether the system or its outputs are being used within the EU, regardless of where an organization is based. Next, I think it is equally important to be clear about what is not covered by the EU AI Act. So, first, AI systems used exclusively for military, defense, or national security purposes are outside the scope of the regulation. Second, AI systems and models specifically developed for the sole purpose of scientific research and development are excluded. Third, and this is also very important for EU projects, the regulation does not apply to any research, testing, or development prior to the system being placed on the market or put into service. Christina will have more to say about this later. Next, we have purely personal, non-professional use, and there is also a carve-out for systems released under open source licenses unless they are prohibited, high risk, or subject to specific transparency rules. Finally, the AI Act does not apply for certain systems already on the market before the relevant application dates, like, for example, high-risk AI already in use before August 2026. Note that these are quite targeted exclusions that are meant to be understood narrowly, right? Moreover, as we will see later on, in practice, even before an AI system moves beyond internal R&D, the Act may become relevant. Let us now move to what is really the fundamental idea of the AI Act, and that is its risk-based architecture. The key idea is that the Act does not regulate AI as a technology in the abstract or in the same way across all situations. Instead, it regulates AI according to the level of risk posed by a particular use case or application. So, when we say that the act is risk-based, we mean that the legal obligations become stricter as the risks to safety and fundamental rights become more serious. In other words, the higher the risk, the stricter the rules. At the same time, the regulation should not be viewed in isolation. Most AI systems are already covered by other areas of law as well, such as data protection or consumer protection law. So, I think it helps to keep in mind that the Act tries to add the rules where they are genuinely needed by this specific type of technology. So, under this logic, the Act essentially works with 4 levels of risk. First, unacceptable risk. These are uses of AI that the EU considers incompatible with its values, and as a result, they are prohibited. We will come back to the prohibited practices in the next slide. Second, high-risk AI systems. These form the core of the Act. Roughly 70% of the provisions target high-risk AI systems. So these are permitted, but they are subject to strict requirements. And compliance with these requirements must be verified before the system is placed on the market. Argyro will describe this in more detail next. The third layer concerns limited, or what we might call transparency risk AI systems. So these are systems that create a risk of deception or confusion, like in cases where people may not realize that they're interacting with a chatbot, or where AI-generated content would mislead them. In such cases, the Act requires clear disclosures so that people understand what they are dealing with. And finally, minimal or no-risk uses. These are all the other applications that do not fall under the first 3 categories. These are not subject to compulsory rules, although other laws may still apply. So, to wrap this up, the takeaway here is that the Act does not treat all AI the same. It calibrates obligations according to preconceived risk categories, ranging from prohibition of unacceptable risk use cases, to strict obligations for high-risk AI, to transparency obligations for certain AI systems, to no obligations for all the other applications. Let us now move quickly through each layer of risk, starting with the prohibited practices. So, which are the prohibited practices? The Act provides 8 use cases which are straightforwardly banned. Note that these prohibitions are applicable since February 2025 and carry the highest fines, so it is good to keep those in mind. So, the first category concerns systems that use manipulative or deceptive techniques in a way that distorts a person's behavior, thereby leading to harm. So, an example here could be an AI gambling app that uses behavioral cues to make you keep betting, thereby causing harm. The concern here is that this undermines individual autonomy and can lead people to take decisions they would not otherwise have taken. The second category concerns systems that exploit the vulnerabilities of persons due, say, to age or disability, resulting in harm. Now, the text makes clear that this harm is not limited to physical or psychological harm, but may also include economic harm. An example here would be a toy that uses tactics to push children to keep making in-app purchases. The third use case is social scoring that results to detrimental treatment. These are systems that essentially rate persons based on their social trustworthiness or infer this based on certain characteristics. This is not about credit scoring systems. It's more about evaluating someone as a citizen. So, whereas, say, in China, this is a common practice, in the EU it is prohibited. The fourth use case concerns criminal risk assessment. This is predictive policing, essentially, like the one depicted in the film Minority Report, for those who might have seen it. Next, we have the prohibition of untargeted scraping of facial images to create databases. An obvious example here, for those who may know it, is the company Clearview, who created a huge facial recognition database based on billions of social media images and received huge fines from several data protection authorities across the EU. The next one is motion recognition systems, specifically in the workplace or in an education context, with certain exceptions. As we shall see, emotion recognition outside these two areas is permitted, but it triggers both the high risk and transparency risk layers at the same time. Next, we have biometric categorization systems, which infer or categorize persons based on sensitive characteristics such as race, political opinions, or trade union membership. The final use case is real-time remote biometric identification when done in public spaces. This is a tricky one. An example here could be a facial recognition tool used by the police in a public square to identify individual. This use case is prohibited, but with certain narrow-defined exceptions. So, those are the prohibited practices sitting at the top layer. Let us now move down the pyramid from prohibited to high-risk AI. Okay, so as we saw, high-risk AI systems are the central focus of the EU AI Act. These are not banned, they are permitted, but because of their potential impact, they are subject to strict requirements. The classification of an AI system as high risk depends mainly on the purpose of the system and the context of use. So it is important to realize that in some cases, the same technology may be treated differently depending on how it is deployed. The Act identifies two broad categories of high-risk AI systems, which, as Christina will explain in more detail next, must comply with specific requirements relating to risk management, data governance, human oversight, accuracy, robustness, and cybersecurity. Let us now move to the third layer. So the third layer is limited risk, or more accurately, transparency risk AI. So this is based on the acknowledgement that it is increasingly hard to distinguish AI from human-generated content. And this raises risks of misinformation and deception. To address this risk, the Act sets out certain transparency obligations. So, for which actors and for which systems do these obligations apply? The first category is systems that interact directly with humans, such as chatbots or virtual assistants. In those cases, the principle is that people should know that they're interacting with an AI. Second, providers of AI-generated or manipulated content, including audio, image, video, or text, must facilitate detection by marking such content in a machine-readable manner through, say, watermarks, metadata, or other techniques. Quite a consequential provision in practice. Third, deployers of emotion recognition or biometric categorization systems must ensure that individuals exposed to these systems are notified. And fourth, we have A, systems generating deepfakes, that is, synthetic content that appears authentic, or B, AI-generated text intending to inform on matters of public interest, where in both cases, deployers must inform users about the origin of the content with certain exceptions. So, these are not systems that are prohibited as such, and they are not necessarily high risk either. The main concern here is to ensure that people are properly informed when AI is used in ways that could mislead or confuse. An important point to also keep in mind is that the transparency risk and the high risk categories are not mutually exclusive. So, the same application can trigger both parts of the Act at the same time. For example, emotion recognition falls under the high-risk layer, and at the same time, it also triggers transparency obligations. Let us now quickly turn to the last slide of this presentation on the main obligations of the main operators of high-risk AI systems in particular. So, as we have seen, the Act assigns obligations along the AI value chain, but here we will focus on the two main roles, which are providers and deployers. So the provider is defined as the entity that develops an AI system or has one developed and places it on the market or puts it into service under its own name or trademark. Providers bear the main responsibility for compliance, with most obligations applying from August 2026. So what are the main obligations of providers of high-risk AI systems? First, they must ensure that the system meets all the Act's AI requirements. These are design and development requirements that Christina will further detail next. Second, conformity assessment. Before placing an AI system on the market, providers must complete an assessment to verify that the requirements are met. In some cases, this is an internal process, while in others, it's not. Argyro will say more about this later. Third, we have documentation and record keeping. Providers must maintain comprehensive documentation covering, amongst others, the system design, its intended purpose, data, testing, and performance, and keep it available for authorities for at least 10 years. And they must also design the system so that it automatically keeps logs. Fourth, quality management and post-market monitoring. Providers must put a comprehensive and systematic quality management system in place that meets certain characteristics and ensures compliance with the Act. But compliance does not stop once the system is deployed. It's their obligation to continue to monitor how the system performs and ensure that it remains compliant throughout its life cycle. This is the post-market monitoring part. Next, incident reporting. So providers have to report serious incidents or malfunctioning to the authorities within the prescribed time frames. Sixth, corrective action. If the provider becomes aware that the system is no longer compliant, for example, new risks may have emerged or its performance may have deteriorated, they must act without delay. This may involve applying an update, changing the configuration, or introducing additional safeguards. In more serious cases, it may even require withdrawing the system from the market, and the authorities may also need to be informed. Seventh, supporting compliance along the AI value chain. So the idea here is that the provider, as the manufacturer basically, has an essential role in enabling other actors to comply. This means providing clear instructions for use, as well as all the necessary information so that deployers, in particular, understand how the system works, what its limitations are, and what they need to communicate to affected persons. Finally, providers also have to register certain high-risk AI systems in an EU database, a measure intended to support transparency, oversight, and accountability. So, as we can see, similar to manufacturers under product liability law, providers are the main actors responsible for compliance, with quite substantive obligations under the Act. Let us now move to the obligations of the deployer. So, the deployer is defined as the entity that uses the AI system under its authority. So, a company using AI for recruitment is a deployer. A bank using AI for credit scoring, or a hospital using a diagnostic tool. Those are deployers. So, while the provider builds the system to meet certain requirements, the deployer is responsible for using it properly in a real operational context. So, what are the obligations? First of all, the deployer has to use the system in accordance with the instructions of use. This is important because the provider's compliance assessment is based on the system being used for its intended purpose and under certain conditions described in the documentation. Second, the deployer must ensure human oversight where this is required. So, while the provider has to build the system so that it allows human oversight, the deployer of a high-risk AI system has to implement it. Another obligation is to monitor the operation of the system. So, the deployer should continuously pay close attention to how the system performs in practice and whether its use may pose risks. And there are also obligations relating to logging and record keeping that also support traceability and monitoring. In case of a serious incident, the deployer may also have an obligation to report the incident. This can include reporting to the provider and, in some cases, also to the relevant authorities. And there are also registration obligations. So, in general, the provider is the one who registers the relevant high-risk AI systems in the EU database. But in some cases, there is a corresponding deployer-side obligation. Public authorities must register themselves, select the relevant system, and register their use in the same database. So this is not a general obligation for every deployer, but it is an important transparency requirement for public sector use. Another important point is transparency towards affected persons. Where a high-risk AI system is used to make or assist in making decisions concerning persons, the deployer must inform those persons that AI is being used in that decision-making process. Next comes the Fundamental Rights Impact Assessment, the FRIA. And this is likely to play an important role in practice, similar to the DPIA under the GDPR. So the obligation sits with the deployer, but it doesn't apply across the board. It's triggered in two situations. First, where the deployer is a public body or a private body providing a public service. And second, where the system is used in specific areas, namely banking and insurance. And the purpose here is straightforward. Before the system is put to use, the deployer has to step back and assess its potential impact on fundamental rights. Finally, and this is actually very consequential in practice, deployers must avoid making unauthorized substantial modifications to the systems. In practice, this means that they should not alter the system beyond what is allowed in the provider's instructions. If, for example, a deployer retrains the model or otherwise changes the system's intended purpose or performance, it may no longer be treated as the same system. In that case, the deployer could be considered the provider of the modified system with the full set of provider obligations applying to him. So, to put this together, and with this I conclude, the deployer is not responsible for building the system according to certain requirements, but he is responsible for, amongst others, using the system properly, monitoring, ensuring human oversight, informing affected persons, carrying out a fundamental rights impact assessment where relevant, registering the system where required, and avoiding making changes or modifications that could undermine compliance. And with that, I conclude, and I give the floor back to Christiana. Thank you very much.
Thank you very much, Nikos. Everybody, you just saw 144 pages of law, 113 operative provisions, and more than 10 appendixes being squeezed in 15 or 20 minutes, quite comprehensively, I will say. The main takeaway is on the very last slide of Nikos. You saw that very crowded slide. Indeed, the obligations for the providers and deployers, but especially for providers, are very, very rich and heavy. So providers are indeed the parties who are sort of in trouble because of the AI Act, especially when their system is a high-risk system. And that leads us to the main question: is our system a high-risk system, attracting all those obligations that Nikos just explained to us? And this question will be answered by the presentation of our next speaker, my colleague Christina Nanu, a legal consultant and a project manager at Eunomia Limited, who is going to speak about this central pillar of AI Act, the high-risk systems, and the big question of classification, as well as let us know a bit more about the requirements that high-risk systems need to meet under the Act. Christina, we are all ears.
Thank you very much, Christiana, and hi, everyone. Thank you for joining. So in this session, we will go through a core matter of the Act, determining when an AI system is deemed high risk and what obligations attach to that classification. So, as Nikos explained, the Act follows a proportionate risk-based approach, as you can see in this pyramid. Right below the prohibited practices, we find high-risk AI systems subject to binding requirements before they can be placed on the EU market. But what does high risk actually mean? It is not about technical complexity. Instead, the legislator looks at three basic criteria: the system's intended purpose, the severity and probability of potential harm, and its impact on health, safety, or fundamental rights. So how do we decide what qualifies? We apply a two-layer test. If either of two classification rules apply, the system is high risk. Let me walk you through both rules. The first rule we can say is the simple one. An AI system is high risk if it is a safety component of a product or the product itself that is covered by specific EU legislation that mandates a third-party assessment procedure before this product is out. Remember, it does not matter if you intend to provide your system already integrated to the host product or separately, something, let's say, to be installed at a later moment. Let's break down this first classification rule. First, the product in question must fall within the scope of an EU legislation enlisted in the first annex of the Act. This annex lists over 20 legal acts separated in two sections. On the one side, we have the new legislative framework, which was a regulatory package, let's say, designed to improve the safety of goods and bolster the CE marking. And at the other side, we have other harmonization legislation governing certain products that you may see in this list. So, if your AI system is a product itself or functions as a safety component for any product covered by these regulations, and that product requires a third-party conformity assessment, then your AI is automatically high risk. There is no discretion, no risk testing required. It is automatic classification. The tricky part of this rule lies with the term safety component, because there are two ways to think about it. First, we should ask, is the AI system meant to perform a safety-related task? This is often very straightforward. For example, an AI-powered sensor, imagine an AI-powered sensor that detects obstacles on train tracks and automatically triggers the brakes. This is clearly a safety component. But there is a second angle, and it's subtler. The question here would be, could the failure or malfunction of your AI system endanger the health or safety of persons or even property? Let's consider another example, a system designed, let's say, to regulate air pressure in inflatable boats, commonly known as rigs. Its job would be to maintain optimal flotation. But if it malfunctions and overinflates, the boat could explode, and that could be devastating for everybody on board. So even though the system's primary purpose is performance optimization, let's say, regarding the flotation, and not safety per se, its malfunction creates a clear safety hazard. That makes it a safety component under the AI Act. Now let's move on to the second rule. The second rule is a bit more complex, and this is where most of the uncertainty lies. An AI system is considered high risk if it falls into one of 8 critical areas listed in Annex 3, the third annex, and if it poses a significant risk to health, safety, or fundamental rights. Now, an important nuance here. Just because a system touches one of these 8 areas does not automatically make it high risk. For each area, the Act lists specific use cases, so not everything under a broad category counts. These use cases may also be altered in the future. The Commission has the power to amend, add new ones or remove some under certain conditions. Let's take, for example, from these categories here, the area of employment. The Act does not cover any HR tool. Instead, it targets specific use cases. For example, AI that decides who gets hired, promoted, or fired, AI that monitors employee performance or behavior, or that it assigns tasks based on personal traits, or if it filters, let's say, job applications. So if your AI system does not fall into one of these specific use cases, it may not be high risk. And this is the first part, let's say, of the second rule. But what about exemptions? An AI system listed in Annex 3 is presumed high risk. However, that presumptions can be rebutted if the system does not pose a significant risk to health, safety, or fundamental rights, including by not materially influencing the outcome of decision-making. If so, the provider must document this reasoning, his argumentation, prior to launch, register the system regardless, and make documentation available for the authorities to check. There are certain conditions for proving that you are under this threshold, allowing exemption for high-risk classification under the second rule to apply. And you may read them here in the second column. You may argue that your system is not high risk when it performs only a very narrow procedural task. It merely improves the result of a previously completed human activity. If it flags, let's say, some patterns or deviations in prior decision-making without, though, replacing the original human assessment, or if it performs a preparatory task that precedes, let's say, something involved in the Annex 3 use cases. Note, though, importantly, that while trying to find how to be exempt from this second classification rule, one case is always out of the discussion. An AI system referred to in Annex 3 shall always be considered to be high risk where the AI system performs profiling of natural persons. And profiling is when you evaluate or predict personal aspects of an individual to determine some outcomes or decisions that may significantly affect that individual. Let's see an example now. You may have, here we have two different applications that may seem very similar, but yet fall under these different risk categories. On the one side, you have a system that automatically grades exam answers and monitors students during a university entrance examination. The AI produces a final admission score that determines whether the student is accepted into a program. On the other side, we have a system that analyzes, let's say, a human performance from past quizzes and suggests optional after-school tutoring modules. It may recommend, for example, you may benefit from such a tutoring lesson this week. So the first system is considered high risk and the second is not, for several reasons that don't apply to the second. It directly determines whether a student gets into a university program and therefore their future education and career opportunities. And this means that it has a severe impact on fundamental rights, specifically the right to education and the right to pursue a profession. And importantly, the decision is final. Once an admission is denied, it is not easily corrected. There is no simple appeals process built in. Let's now move to the requirements attached to a high-risk system. Once your system is, before that, let's summarize the two rules. So we have rule 1, a certain regulated product or a safety component of such a product, and critical use cases posing a significant risk to health, safety, or fundamental rights that does not benefit from an exception. So once your system is classified as high risk, Articles 8 to 15 impose a number of mandatory requirements. Let me walk you through them. First, you must establish a risk management system. You have to continuously identify, assess, and find the mitigation measures for risks to health, safety, and fundamental rights, including to foresee, for example, potential misuse of the system, even if this is done by a person, or is it from the fact that the system interacts with other systems. You must also, your system has to have built-on data sets that meet strict quality standards. So your testing, validation, and training data must be relevant, representative, as error-free and complete as possible, free from bias, and appropriate to the specific setting where the AI will be used. Third, you must prepare comprehensive documentation, and this is burdensome, demonstrating compliance with all of the Act's requirements, providing in this way clear and complete information to the authorities. This shall contain the information enlisted in the Annex 4 of the Act, including, for example, the general description of the system, its intended purpose, a detailed account of its development process, including algorithms, architecture, training data, testing procedures, cybersecurity measures, a description, for example, for its performance limitations and foreseeable risks. And also, you have to document down what is your risk management system, if you have any harmonized standards applied, your EU declaration of conformity, and of course, the post-market monitoring plan that Nikos mentioned earlier. In short, you must demonstrate the system compliance across its entire life cycle. So fourth, your system must be technically designed in a way that it automatically logs events throughout its lifetime. These logs serve three functions: identifying situations that could lead to a risk, facilitate post-market monitoring, and monitor the system operation itself. These logs must be kept for at least 6 months, designed to be kept for at least 6 months. So going to the fifth, your systems must be designed so that the people using them can understand and properly use the system's outputs. You must give clear and complete and accessible and easily understandable language instructions for use. These instructions must include your identity, your system intended purpose, its accuracy, its known limitations, risks, etc., and instructions on how to interpret outputs and manage the logs. Again, also, your systems must be designed to allow for meaningful human intervention while in use. These measures, though, are not the same for each system. They must match the system's particular risks, its level of autonomy, and the context. And also, you must be careful that the humans in charge must be able to understand the system's limits, to monitor for anomalies and avoid over-reliance, and if necessary, to be able to override or shut down safely. And finally, your high-risk system must achieve an appropriate level of accuracy, robustness, and cybersecurity. So you must declare your accuracy metrics, and your system must be resilient to errors, faults, or inconsistencies. And if your AI continues learning after deployment, you must eliminate or reduce biased feedback loops that could corrupt future outputs. Critically, the system must be resilient against attacks by unauthorized third parties, for example, let's say data poisoning or generally confidentiality breaches. So these 7 requirements form the backbone of compliance for high-risk systems. While trying to conform with these requirements, one must keep in mind that, that compliance must be both purposive and realistic, grounded in the current technological state of the art, which by itself is a difficult task. And if your AI is part of a product that already follows other EU safety rules, you can reuse your existing paperwork and tests to satisfy the Act, so you don't have to do the same work twice. And this is why risk management acts as a kind of a compass. It helps you understand in each case and decide what is proportionate and appropriate for your specific system. In addition, a conformity assessment is required, but in this regard, Argyro would tell us more later. So to summarize, first, you have to classify correctly using the 2-layer test, then align your compliance effort proportionately to your risk level, reuse existing documentation where possible, and document everything throughout. That is the path from classification to readiness. And this is all from my market readiness. This is all from my side. Thank you.
Thank you very much, Christina. I like the way how calmly you are breaking the saddest news under the AI Act. Your system is a high-risk system, and you have all those requirements to meet and comply with and worry about. So let's proceed now with our next speaker, Giovanna Lopez, a postdoctoral researcher at Tilburg Institute for Law, Technology and Society. So far, we have been talking about AI systems. But at the very beginning, if you remember, Nikos told us that the AI Act also refers to AI models and general purpose AI models in particular, the brain of the system, let's say. But Giovanna will tell us more on these models and the code of practice. Giovanna, the floor is yours.
Thank you very much, Christiana, for the introduction, and thank you everyone for being here today. It's a pleasure to be a part of this workshop, and this specific session will now focus, like Christiana just mentioned, on the AI Act's provisions regarding general purpose AI models, or GPAI models, as in the abbreviated form, as well as the code of practice. So during the session, we will see the definition of GPAI models and systems, and where these models fit within the risk-based approach of the AI Act that was just presented by my colleagues. Then we will look into the obligations directed at the providers of these models, which mainly relate to transparency obligations. We will then explore a particular category of GPAI models, which are those posing systemic risk, and see what are the additional obligations that are imposed by the AI Act on the providers of these types of GPAI models. Finally, we will look into the code of practice, whose voluntary application or adoption serves as a way to demonstrate compliance with the AI Act. So as a way for providers to actually show that they're complying with the AI Act, so following the rules that are defined in the code. So according to the AI Act, a general purpose AI model is a model that displays significant generality and that is capable of performing a wide range of distinct tasks. These models can then be integrated into downstream systems, which leads them to then being classified as a general purpose system. So to give an example, we have GPT-4, or I think 5 now, which is the GPAI model, while then we have ChatGPT, which includes the user interface and is defined as a general purpose AI system. So models are a broader category. And these are, there are some key functional characteristics that actually make general purpose AI models distinctive. These include, like I said, their generality and the capability to perform a broad range of tasks. The fact that they are typically trained on large amounts of data, and like I mentioned earlier, the fact that they can be an essential component of some AI systems once other elements are added, such as a user interface. And within the AI Act's risk-based approach, the provisions on GPAI models occupy a unique position, as these models do not fit into the traditional risk categories that were just presented. And there are two explanations for this. First, GPAI provisions were not part of the original architecture of the AI Act that was proposed by the European Commission in the 2021 draft. They were only included later on through additions, first by the Council in 2022 and by the Parliament in 2023. And these additions actually followed the release and the immediate success of ChatGPT and other generative AI models that became famous. The second explanation is that GPAI models can give rise to very distinct risks and to regulatory challenges when they are compared to more specific AI applications. So this is because of something that is referred to as emerging capabilities. This means that as the models improve, they start to acquire capabilities that they were not explicitly trained for, and that as such cannot actually be predicted in advance. And this is especially true for the more advanced or frontier models. So the AI Act imposes baseline transparency obligations to providers of all GPAI models, and then a subset of more strict obligations to providers of frontier models, which are the ones that will pose systemic risk. Let's see first what are the general obligations for providers of GPAI models, so the broad ones. According to Article 53, providers of GPAI models must draw up and keep up to date the technical documentation of the model, as well as make available this documentation and information to providers that want or may want to integrate their model into their AI systems. They also need to put in place a policy to comply with relevant copyright law, because these types of models can actually violate copyright protections both at the input stage, so when they are being trained, but also at the output stage, so they can infringe copyright with their outputs. And finally, providers also need to draw up and to make publicly available information about the content that is used for the training of the model. And this should follow a specific template that was already provided by the AI office and can be found on their website. So within the broad category of general purpose AI models, the AI Act then classifies some as having a systemic risk. So according to Article 51, a GPAI model is classified as having a systemic risk under two conditions. The first condition is that the model has high impact capabilities, which is assessed via technical tools and methodologies. But here the Commission actually created a quantitative presumption. So according to the Commission, if the model's training compute exceeds 10 to the power of 25 floating point operations, which is something massive, it is automatically presumed to have high impact capabilities and therefore to pose a systemic risk. And then the second condition is if the GPAI model is actually designated by the European Commission as having equivalent capabilities or impact using criteria that is laid out in Annex 13. So this actually, the second provision allowed the Commission to perhaps capture some models with an impact equivalent to the most advanced ones, so the first option, but that perhaps fall just below the quantitative threshold of the previous presumption. The criteria for designation of GPAI models with systemic risks is listed in Annex 13, like I said, of the AI Act, and includes, for example, the number of parameters listed, the number of parameters of the model, the quality and the size of the data set, the amount of computation used for training the model, and the number of registered end users. So all of this will be taken into account to classify a GPAI model as having systemic risk. And providers of GPAI models with a systemic risk need to comply, in addition to the transparency requirements that were mentioned earlier, with specific and more strict requirements that are then listed in Article 55. So they have to perform model evaluation following standardized protocols and tools that reflect the state of the art. They also have to assess and to mitigate possible systemic risks. They need to document and to report any serious incidents and corrective measures, and they need to ensure an adequate level of cybersecurity protection. And in order to facilitate compliance with all these obligations, the AI Act foresees the creation of a code of practice, establishing some more clear parameters for ensuring and for demonstrating compliance. So we saw that the GPAI provisions were not actually part of the AI Act's original architecture, and they were only added later on in somewhat of a hurry. And as a result, you can see that a lot of the provisions are very underspecified, especially when we compare there to the level of detail, for instance, on the provisions of high-risk AI systems. So this is also part of what makes a general purpose AI code of practice necessary, to clarify some of the previous obligations. The final version of the code was published in July 2025, so the code already exists. It was prepared by independent experts from different backgrounds. So there were members from industry, from academia, from civil society, and they together prepared this finalized version of the code. And like I said, the code defines a way for providers to demonstrate compliance with the AI Act obligations for general purpose AI models. But it should be noted that the code, the adoption of the code is actually voluntary. And this means that the providers that choose maybe not to sign it will need to demonstrate compliance via different mechanisms. So it's not mandatory to sign the code of practice. But still, most of big tech companies, which are the ones that currently provide these frontier models and the models that actually pose a systemic risk, have already signed this, the code of practice. So for instance, Anthropic, OpenAI, Google, Amazon have all signed the code of practice, and there's a list on the European Commission website that you can keep up to date with the signatures. So the code is divided into 3 chapters: transparency, copyright, and safety and security. While transparency and copyright chapters are relevant to all GPAI providers, the safety and security chapter only applies to GPAI models that actually have a systemic risk. So to give an example, the transparency chapter offers a form, a model documentation form, which allows providers to actually document the information necessary to comply with the obligations that we saw earlier, the transparency requirements. The copyright chapter mentions some techniques that can be used, for instance, to respect rights holders opt out when they don't want, for instance, their work to be used to train general purpose AI models. And importantly, the safety and security chapter outlines also some state-of-the-art techniques and practices for managing systemic risks. And also what was very welcome is that the Appendix 1 actually provides a guidance on how to identify what are the types, the nature, and the sources of systemic risk that they must assess, and also defines some default systemic risks. So there's a list of default systemic risks, which includes chemical, biological, radiological, and nuclear risks, loss of control, cyber offenses, and harmful manipulation risks. So in any of these instances, there will be the systemic risk will be by default. And finally, to conclude, when it comes to the timeline for compliance, the providers placing new models on the market need to comply, already started to needing to be compliant with the AI Act provisions starting early August 2025. But those who have signed the code of practice were granted some sort of grace period. And this means that until August 2026, so for a year, they will have a presumption of good faith in case of violations. This means that they will not be sanctioned, so they will not, for instance, receive a fine in case of a violation. They will only need to work closely with the EU AI office in order to then become compliant. But after this grace period, then yes, the Commission will start fully enforcing compliance with all GPAI obligations. And for the models that were already placed on the market before August 2025, the AI Act, they will need to comply with the AI Act obligations starting from August 2027. So they were granted a bigger period of adaptation. That's it on my side. Thank you very much. And I look forward to the discussion and the Q&A later on. Thanks.
Thank you very much, Giovanna, for this very clear and comprehensive overview of the rules on general purpose AI models, and on the code, which, as you very correctly said, is the aim is to facilitate compliance, and indeed providers are very much in need of such assistance and support in complying with these rules. So let us now proceed with our fourth and last presenter for this first part of our workshop. It's Argyro Hatzopoulou, co-founder of Aperoplus Services, and she will talk to us about conformity assessment for high-risk systems and the role of testing in this conformity assessment, which I have to say that conformity assessment is a main obligation that needs to be complied with. So, Argyro.
Thank you very much. Let me just check that you can hear me.
We do.
Is it okay?
We do.
Great. So it's really great to be here, and thank you very much for the invitation. And I would like to thank also the previous presenters, because they did an excellent job describing something that is very complicated in very simple terms, and also offering a bit of an introduction to conformity assessment. So both Nikos and Christina actually said that one of the requirements that come with the AI Act is that of conformity assessment. So after all this introduction, now it's time to discuss about what conformity assessment is. So I have been working within this the area of conformity assessment for almost 20 years now, and always when I start in discussions regarding conformity assessment, I always like to put a little bit of a definition, because maybe we would call conformity assessment as a niche, especially in the area of technology. We may not have heard a lot about it. So the first things that to be said is, what is conformity assessment, which is something that is very, very simple. It's actually the conformity assessment is demonstrating that specific requirements are actually being fulfilled. The specific requirements relate to an object, to the object of conformity assessment, which could be a product or a process or a service or a system. But what it actually means is that for this entity, these requirements have to apply, and we get to check whether these requirements are actually being fulfilled. So we have the object of conformity assessment and conformity assessment. And this demonstration, how we show that these requirements are being fulfilled, can be done in various ways. Some of these ways could be testing or inspection or validation or certification. So we have different ways, different activities that could be implemented in order to demonstrate that specific requirements are being fulfilled. And depending on who performs these activities of checking, of demonstrating that the requirements are being fulfilled, we have three main types of conformity assessment activities. So we have first party, second party, and third party conformity assessment activities. And I know most of us have heard at least of the first and the last, and so I think that would be the most easy to describe. First party conformity assessments are activities that are performed by the same entity that actually has this interest in this specific object of conformity assessment. So this would, in simple terms, this would mean that if I want to prove that my organization, for example, fulfills specific requirements, then I get to check it myself. So the general manager authorizes and assigns to somebody, either internal or external, to check whether the requirements are being fulfilled. Whereas the last part, the third party conformity assessment activity, is that this demonstration, this checking, is being performed by an entity that is completely independent. Because if I'm performing the activities of checking, then of course there is some kind of bias and some kind of it's not as independent as it would be by a different organization that has absolutely no connection and no relationship with my organization performing this check. So having said these main things, then we can talk about a little bit about who are the entities that are involved, especially in the last part, so in the third party conformity assessment activities. And these are called conformity assessment bodies. So these are entities, bodies that perform the conformity assessment activities, and by default and by design and based on the international standards that their operation is based upon, they are independent and should have no relationship to the organization that is undergoing the conformity assessment activity. And another step or another differentiation of these conformity assessment bodies is that in some cases, including the AI Act, these bodies have to be notified, which means that they have to be designated by an EU country in order to assess the conformity assessment of a specific product. So there's another process that goes on top of having a body act as a conformity assessment body, and that is to be notified by a member state. And this notification, there are lists of the notified bodies. It's a very formal thing. They have to be decisions, and there are specific regulations that make sure that these are followed and observed, all the requirements are followed and observed. And there is this website where anybody can go and see which are the notified bodies for the specific product that they are looking for. And I have put a screenshot here of the notified bodies that are currently within this website for the AI Act. And as you can see, there is no entry for other things. For example, in this case, for the safety of toys, there are bodies, 35, for example, but not yet for the AI Act, because we are not in full operation of all these activities. So now that I have established a little bit what conformity assessment is and who is involved and what is the difference between notification and conformity assessment, now it's time to talk a little bit about examples and how conformity assessment actually works within the AI Act. So I have selected one example of a high-risk AI system, and Nikos in the first presentation and Christina in the second talked a little bit about which are the kinds of the types under Annex 3 of high-risk AI systems. For example, here we can say that we have a system that, an AI system that is performing a remote biometric identification. Based on what Christina said in her presentation, this high-risk AI system has to fulfill specific requirements. So Section 2 contains requirements for high-risk AI systems, and you can see here a list. I will not go through them because Christina did an excellent job talking about it. What I am going to focus on is on the last part of this slide, which is how do our organizations that have such an AI system supposed to demonstrate compliance to these requirements. So if the provider has applied harmonized standards, and we will talk about it about that in a little bit afterwards, they have different options. So one of these options, and I know this is very complicated and conformity assessment lingo that you see here, but I will try to break it down in the next slide. One of the options is the internal control referred to in Annex 6, and the other one is the assessment of quality management system and technical documentation by a notified body. This is where the notification comes in, as it denoted in the Annex 7 of the AI Act. So what does internal control mean? So actually, internal control is self-assessment or first-party assessment that I was talking about before. So this means that I have a provider of an AI system, and this provider of the AI system has to demonstrate by themselves that their AI system actually fulfills the requirements in Section 2 of the AI Act. So that means that the provider has to verify that the quality management system is in compliance with the requirements that are stated in Article 17, that the provider has to examine that, has to, of course, create the technical documentation that Christina described in her slides, and they have to examine also that the information that is within the technical documentation actually fulfills the requirements that are stated within the AI Act, and that they have to verify that the design and the development process of the AI system and everything that has to do with the post-market monitoring that the AI Act requires are actually being fulfilled. So they have the ability to select whether they will go for self-assessment, or they have the next part that is a conformity assessment process that is based on Annex 7 of the AI Act, which is actually the third-party assessment process. In this case, the provider by themselves cannot demonstrate that they fulfill the requirements of the AI Act. They have, or specifically of Section 2, since we are talking about an AI system, they have to go to a notified body, and that notified body has to check that their quality management system satisfies the requirements, and that the technical documentation also fulfills the requirements. And in doing so, the notified body, and you can see it here in the slide, I don't know if you can see me moving around my mouse, they may request or perform by themselves different tests in order to make sure that the technical requirement, that the requirements and the statements that are done and included as part of the technical documentation are actually true. So there is the ability to verify the quality management system, to examine documentation, and also different parts of different information that the provider is giving to the notified body, including information on the training, the validation, the testing data sets used, the performance of the APIs, and so on and so forth. And the last part of the activities of the notified body is also to perform periodic audits. So it's not something that is done once off, and then the provider is giving this documentation in order to circulate their product in the market, but they have to make sure that whatever requirements are stated, both from the management system perspective, but also on the part of the AI system and the technical documentation of the AI system is also being fulfilled during the years that the provider also maintains this AI system. So we have different options. They have different rigor, different effort, and different interested parties that have to be involved. And of course, they have different value. It stands to reason that any conformity assessment process that belongs to the self-assessment part is me actually saying that I fulfill the specific requirement and it has a certain value, whereas a third-party conformity assessment process is not just me saying something, but actually a fully qualified, capable, and notified body that is independent completely from the organization is saying that you fulfill these requirements. So if the provider is not fulfilling the harmonized, is not using harmonized standards, or has not applied fully the harmonized standards, or the common specifications that are described within the AI Act are not fulfilled, are not present, or are partly implemented, then in this case, the ability to do self-assessment is no longer available. So the choices that we have here in this slide are actually diminished to only one choice, which means that they have to go to a third-party assessment process. So, here it comes to the discussion that we need to have regarding harmonized standards. So there is the European Commission, as soon as they created the AI Act, they knew that they have to make sure that the market has standards that could be followed uniformly by AI providers in order to fulfill the requirements under the AI Act. So this is why they created very quickly a standardization request, and you can see here in this slide the standardization request, where they requested from the European standardization organizations like CENELEC to create the relevant standards. The standardization work in support of the AI Act has started, but not yet completed. You can go and see the different standards that are in preparation currently from the AI Act. I have put also, to support the AI Act, I have put also examples. And I am showing you here one of them, which is the 18286, which is going to be the harmonized standard to be used by AI providers to construct and demonstrate compliance against the requirements for the quality management system. So you can see here we'll have a standard that is going to be approved within the year, hopefully. And this is what the providers can use in order to demonstrate their compliance. And if they use that, then depending on the type of AI system, the classification of the AI system they have, they can also use that in order to prove compliance. So for that, with that, I conclude this presentation. Thank you very much, and I give the floor back to you. Thank you.
Thank you very much, Argyro. You really put the lens on this conformity assessment process, and you made things much clearer, because we are concluding now the first part of our workshop. Let's have our short 5-minute break, and then we can all be back for the second part, the more practical part of today's event. So hello again, everybody. Thank you for being here with us. We are moving now to the second part of our today's workshop. We have Christina Nanu again, who will speak about the research exception. You know, this exception is a very important one, and we often see people being eager to fall within the exception, and I think we all understand why now. If they qualify for the exception, that means that they need not bother with conformity assessment or all those requirements and all those obligations. However, it seems that the research exception is not so broad as it may appear at first. And this is what Christina will explain to us. She will discuss the research exception and its limits. So, Christina, the floor is yours.
Thank you again, Christiana, and hello, everyone, again. So in this session, we will look at two specific cases of exemption from the AI Act, both directly relevant to researchers working on AI systems. And we will then walk through the ethics obligations that are within Horizon Europe projects. So two complementary frameworks shape how AI is built and used in EU-funded research: the AI Act and the Horizon Europe Ethics Framework, binding researchers to certain obligations. Since the publication of the famous Guidelines for Trustworthy AI in 2019, and even more so since the Act's publication, which essentially codifies many of those same ethical commitments into binding law, researchers face two persistent challenges. When does the Act apply? When does it not? And what ethics obligations apply to researchers? So let's begin with the first by going through the two relevant exception rules of the AI Act. The first exception is Article 2, Paragraph 6, the scientific research exemption. The text reads, "This regulation does not apply to AI systems or AI models, including their output, specifically developed and put into service for the sole purpose of scientific research and development." Let's make some clarifications to this provision. The exemption covers not only the AI system itself, but also any results, predictions, or outputs it produces. Research datasets and model outputs are protected too, as long as they remain inside the research context. Moreover, the legislator deliberately chose the word specifically and for the sole purpose to narrow down this exception, to make it stricter. The Act is asking whether the system was built from the start with the research as its only objective. A system designed for commercial product but tested in a research setting does not qualify. So both the stages of development and deployment must remain within the research purpose. If the system is later put into service for any other use, the exemption stops applying from that moment on. And lastly, the concepts of scientific research and development follow the established definition in EU R&D programs, like systematic investigation aimed at gaining new knowledge. It does not cover routine product testing or commercial pilots dressed up as research. Now let us turn to the second exception. Article 2, Paragraph 8 reads, "This regulation does not apply to any research, testing, or development activity regarding AI systems or AI models prior to their being placed on the market or put into service. Such activities shall be conducted in accordance with applicable union law, but testing in real-world conditions shall not be covered by that exclusion." Let us clarify some terms here as well. So, placed on the market is a defined term in EU product law. It means the first making available of a product on the union market for distribution or use, whether for payment or free of charge. And this is not to be noted. Secondly, pre-market does not mean lawless. Like if you are exempt from the AI Act, other regulations such as the GDPR or other sectoral regulations still apply. And lastly, testing in real-world conditions. This is where it gets tricky. The moment you run live tests with real users in real environments, these exemptions may not apply. Until further guidelines are issued by the European institutions, the safest approach here is interpretative caution. What exactly qualifies as real-world testing remains a bit unclear, an uncertainty that becomes particularly pressing when attempting to determine which technological readiness level stage activities fall within that meaning, especially in a research context that prepare for market readiness. As we know, the Horizon Europe framework uses the TRL scale from 1 basic principles to 9 commercial systems. Many Horizon Europe projects operate somewhere in between and often involve real-world pilots. Starting from TRL 1 to 3, any activities within this range fall clearly inside the Article 2, Paragraph 6 exemption, the scientific research exemption. The uncertainty, though, increases as the scale increases, from TRL 4 to 6, the development, let's say, stage, and while you move to validating and demonstrating a prototype outside the laboratory, the activities there may or may not amount to real-world testing in the sense of 2, paragraph 8. And once a project crosses, let's say, into TRL 8 or 9, real-world testing is essentially the point of your activity. So this is the critical question every research consortium has to answer for itself. When the Act's exemptions are unclear, how should the project actually behave? There are essentially 3 positions. So you may go to option A, the Act is not a concern. Treat the research are wholly outside the Act's scope. This works for generally upstream research, TRL 1 to 4, where you are nowhere near deployment. But the moment your system touches real users or real data, this position becomes a bit fragile. And then you go to option B, to treat the Act's central duties as design constraints from the start. Put record keeping, transparency, data governance measures in place, and most of these measures are achievable as by design requirements during the project itself, with relatively little overhead. This is the option that scales best for TRL 5 to 7 work. And then you have option C, to treat the system as in scope and fully abide by the very burdening technical documentation, risk management requirements, etc. This is the heaviest option, and it's obviously disproportionate for early stage research, but it is the right call when the system is close to deployment and market readiness. So these choices shape up your documentation, your risk management, and for example, what a downstream commercial partner, a company, let's say, would get from you if they later turn your research into a real product. Projects usually choosing option B may sometimes drift into option C as the TRL increases, and that progression should be a deliberative, justified decision. But in contrast to the uncertainty acknowledged here, researchers in any case still hold the legal commitment to act in a certain way when conducting research with AI. So let us turn now to ethics. Unlike matters of, private conscience or subjective preference, the ethical commitments under Horizon Europe are normatively binding. They derive from shared rational principles, institutional rules, and legal frameworks. The legal basis for binding research to commit to ethical principles are, in a general way, 2. Article 19 of the Horizon Europe Framework Program, which says a high-level obligation, and Article 14, which turns the same commitment into a contractual obligation that every project consortium partner must abide to. And there are 3 key EU reference documents that shape up the ethical framework to abide by. So we have something that is prior to the project being active. We have the ethics self-assessment, which is guidance that you have to complete at your proposal stage, but also to incorporate in your project. And then you have the ethics by design guideline, explaining how to translate ethical principles into concrete engineering choices and essentially treat ethics requirements not as a final stage compliance check, but as requirements to be built into the system from day one. And then you have the famous ethics guidelines for trustworthy AI, the conceptual, let's say, foundation underpinning both the previous documents and the AI Act itself. So let's take a closer look at the latter. The guidelines set out 4 ethical principles, which are then translated into 7 more concrete requirements. The 4 principles: respect for human autonomy, prevention of harm, fairness, and explicability, the latter mostly related to AI, resonate with the fundamental bioethical principles of beneficence, not to do good, non-maleficence, to not do harm, autonomy in the strict sense to respect self-determination of individuals, and justice. The 7 key requirements then translate these abstract principles into concrete operational checks, practical sub-requirements and obligations that must be examined on a case-by-case basis. Another guiding document, part of the Commission's experts group guidance package, is the assessment list for trustworthy AI, known as ALTAI. It is a practical checklist that helps you determine step by step whether you have fulfilled each of the 7 requirements. So the Act, as I mentioned, essentially reflects these guidelines. And in many ways, conformity with these ethics guidelines is not only a legal commitment when you participate in a Horizon Europe project, it is also a pragmatic pathway towards alignment with the Act itself. So even research that is exempt under Articles 2, Paragraph 6 or 2, Paragraph 8 carries ethical obligations that must be examined and adhered to, and these obligations are contractual. In effect, you are complying with the key aspects of the Act, even when its legal text doesn't formally apply to you. Here are, for example, some areas that there is the Act and your ethical obligation coincide. For example, let's see data governance. Article 10 of the Act mandates representative, error-checked, bias-tested datasets for high-risk system, and the guidelines also have a section privacy and data governance that predates that and underpins it essentially and prepares you for it. The practical insight is that many AI Act provisions can be satisfied as ethics by design choices made very early in the project, which means that a well-run Horizon Europe ethics process gets you most of the way to Act compliance. But for the harder part, there are also challenges. The EU ethics framework is actually excellent at its values, but for research teams dealing with AI, certain problems face very fast in deciding an implementation plan, and some overarching challenges are these ones shown here. For example, the proportionality versus precaution challenge. Although the ethics guideline says that you have to apply only the necessary measures, what is necessary for a research prototype that might become a product is unclear. There is no stage guidance. The framework treats every system as if it carried the same risk profile, and that brings us to the second challenge. The same AI systems can present fundamentally different risk profiles depending solely on the context of its use. The framework treats both low-risk and high-risk application contexts identically, leaving somehow researchers unsure on where to stand. And third, projects may have an inherent limitations for fully abiding to certain obligations. There may not be enough resources to stretch to all the requirements, not enough time, or even data. For example, one question is in the ethics assessment checks if you have tested for bias. This is a fair question, but in early high TRL research, you may not have diverse real-world data yet. This is precisely what the project is trying to obtain. So research may only restrict their answers to a justified, let's say, response and a future strategy that actually will satisfy the obligation. So sometimes the risk and result is a research either over-document, wasting time on box ticking, or under-assess, risking, let's say, bad results on reviews. But apart from the challenges we identified here, that are related to the research context itself, we have also gaps and challenges in the guiding documents themselves. For one, both some guiding documents and ALTAI doesn't differentiate between different technological readiness levels. The ethics checklist is the same for, let's say, a sandbox test and a live pilot, and these are clearly not the same kind of activity. Also, there is no research to product transition guidance. When your project moves from Horizon Europe into a startup or hands results over to a commercial partner, what ethics artifacts transfer? Which ones need updating? This is out of the scope of the assessment. Moreover, more guidance could be practically useful regarding the methodology and the different stages through which the assessment is conducted. For example, there is no reassessment timing guidance, no component level breakdown, especially for multiple partner platform integration with many components come together, etc., which is the most often case. And perhaps the trickiest part of all is the task of defining appropriate technical metrics. This remains persistently difficult due to domain-specific context, inherent research limitations, and of course, a continuously advancing state of the art. And one last thing to note as a gap, it's that the ALTAI, for example, was finalized in 2020, so general purpose AI was not yet on the radar. Foundation models, large language models, etc., were not specifically addressed. So to close this session, I would like to highlight the following 4 takeaways. So the AI Act research exemption is real, but is narrow. It protects basic research. It does not shield high TRL projects, and we should move forward until further guideline is in, with reading it carefully and applying it conservatively. But we could perceive the Horizon Europe framework as closing this gap. Full ethical governance is required regardless of the AI Act exception status. And that requirement is contractually binding, so we cannot be exempt from that. Most importantly, good ethics management creates a pathway for a smooth transition to full compliance with the Act. Also, regarding the tools we have at hand, ALTAI may be a starting point, but it's not a finalized tool. It is vague, it is static, it is underspecified for agile high TRL research, and for these reasons, projects will still need to compensate with their own internal practices. And finally, we have to treat ethics as continuous, TRL aware, and documented, and keep pursuing through the consultation channels available to projects for formal guidance, like for example, from our external ethics advisor boards, our national authorities, to keep getting guidance on research to deployment for the research to deployment boundary. This is where the real uncertainty lives, and it is the gap most worth closing. So this is all from my side. Thank you very much.
Thank you very much, Christina, for this presentation too. We should be careful, as we saw with the research exception, and have it in mind, try to qualify, check if we qualify, but not take it for granted that if we do research, we qualify, because this is not the case, as your presentation made clear. So moving on now to Nikolaos Kouliarakis again, and Nikos will let us know of AI governance good practices for EU projects in particular. So, Nikos, you have the floor. We cannot hear you. All right. Okay.
Sorry, I was muted. So thank you, Christiana, and thanks to everyone for keeping with us. So this presentation is about governance good practices for projects in line with the AI Act. It's meant to be more practical. Can you see my screen?
We do.
Okay, perfect. So, in what follows, I am going to outline a practical workflow that projects can use to demonstrate alignment with the EU AI Act. The question here is basically how your project can utilize the Act and the related implementation machinery to achieve ethical excellence, support legal compliance, and potentially move closer to market readiness. And the core idea here is this: the Act should not be viewed as a siloed compliance exercise. Even when it does not fully apply, ethical excellence mandates building mechanisms that demonstrate responsible development and potentially readiness for future exploitation. So, this is the workflow at a glance. 7 steps that move a project from kickoff to handover, sequenced as a practical AI Act alignment workflow. So, the steps include building an AI inventory, screening against prohibited practices, risk classification, role determination, incorporating legal requirements to design requirements, managing risk during the build and the pilot phases, and maintaining proportional documentation throughout. Note that in practice, these steps look back. Classification can shift, design requirements may need revisiting, and documentation accumulates across all stages. Let me note in passing that obviously there are other important AI governance enablers as well, like, for example, AI literacy training and awareness initiatives like the one we're having, or utilizing established risk management frameworks specifically dedicated to AI, like the AIRMF from NIST or the ISO 42001. But for the sake of time, we will set those aside for the session. So let us now quickly go through each step of the workflow in turn. So the first step is the mapping of all AI components in the project. The idea here is to create a comprehensive inventory that will serve as the reference point that all subsequent steps draw from. In this respect, at least 6 dimensions are worth capturing for each AI component. First, the systems and models themselves. Here, the goal is to be specific enough to avoid conflating systems and models with different obligations. Second, who owns or develops each component? This obviously clarifies responsibility and also informs the role determination step. Third, the intended purpose. This is essential and will serve as the basis for the risk classification exercise that will follow. Fourth, adequate information about the training, testing, and validation data, with connections to ethics, GDPR compliance, and the overall governance. Giovanna will have more to say about this next. Fifth, the users and deployment context. This is also relevant for the risk classification, as well as the evaluation of the relevant exemptions under the AI Act that Christina explained. And finally, the lifecycle stage and potential exploitation plans, as these also directly affect whether the Act applies and what comes next. Now, the inventory should be seen as a living dog that has to be updated whenever a new component is introduced, when an existing one is changed, or as deployment plans evolve. Finally, note that this step is not meant to exhaust the full set of documentation that may be required, right? So we will return to this later at step 7. Step 2. So, step 2 is screening against prohibited practices. This comes immediately after the inventory because there is usually no point in continuing if the system cannot lawfully be deployed in the first place, right? So, the 8 categories on the left reflect the prohibited practices. We saw them before. I will not go into those again here. I would only recall that each prohibition has its own conditions, and the Commission has published guidelines clarifying the scope. So, the idea at this stage is to treat the screening as a binary gate and to start produce some evidence. If the conclusion is negative, this should be documented. Whereas if red flags are identified, the issue should be escalated. And it is also important to repeat the process whenever there is a substantial modification, like a change in the intended purpose. A final point to note here is that the R&D and the scientific research exemptions are especially relevant because research into practices that would otherwise be unacceptable is not automatically prohibited. So this is explicitly stated in the Commission guidelines. To give one example, a research project could in fact study how people react to subliminal or deceptive AI techniques if this is solely for the purpose of research. However, as we have seen, The applicability boundary is crossed where the system is placed on the market, put into service, even merely for internal use, or tested in real-world conditions, at which point the prohibitions start to bite. Next, at step 3, the project performs the risk classification for each AI system. The screening questions that will appear on the slide map to different obligation layers that we have seen. So first, could the use case be high risk? As Christina explained, this is the case if the system falls under any of the Annex 3 areas, like education or critical infrastructure, or if the system is a product or a safety component of a product subject to third-party conformity assessment, like medical devices. So, as we have seen, high risk classification is the most consequential. Second, do transparency obligations apply? Again, regardless of whether a system is high risk or not, the Act may impose disclosure or labeling obligations for certain AI systems, including systems with direct human interaction, deep fakes, emotion recognition systems, etc. Third, are general purpose AI model issues present? This is increasingly common in practice. Here, we need to understand whether we are merely using a foundation model, whether we are integrating it into an AI system, building downstream applications on top of it, substantially modifying it, because each of these activities can position the project differently along the AI value chain. Finally, if the intended purpose or deployment context change, the classification should be revisited because it may change as well. So step 4 concerns the role determination. So once we know what obligation layer applies to each AI system, the next question is who carries the obligations under the EU AI Act. Here, we can identify some common patterns. So a technical partner that develops an AI component is likely a provider if it places the system on the market or puts it into service under its own name. Second, a pilot running the AI system in its operational environment. This is likely a deployer if it uses the system under its own authority. Third, in this case, we have the use of a third-party LLM through an API, for example. So in this situation, the initial provider remains responsible for the model, but the project may become responsible for the downstream AI system built on top of it. The final case is where a partner substantially modifies an existing AI system, in which case the partner may become the provider of the modified system, especially where the modification changes the system's intended purpose or affects its compliance with the EU AI Act. Finally, note that the same entity can be both a provider and a deployer for a single component, or a provider for one component and a deployer for another. So step 5. Step 5 targets requirements that have to be designed into the system itself. The key message here is that even where the Act does not yet apply, projects should not postpone their alignment until exploitation. Otherwise, compliance may require a difficult retrofit. So let me break this down real quick. Up to this point, we have identified the system, we have screened for prohibited practices, classified the risk level, and determined the likely roles in the value chain. The question now is, what does this all mean for the design of the system itself? This is the point where we translate the previous analysis into technical and organizational requirements. So, as we have seen, for EU projects during the research phase, some obligations may not yet apply. But if the system may later be exploited, put into service, or commercialized, the AI requirements, and especially those affecting design aspects, should be anticipated. So, for example, if a system is classified as high risk, the project should anticipate related requirements such as on data quality, logging and record-keeping mechanisms, human oversight capabilities, as well as accuracy, robustness, and cybersecurity requirements. Likewise, if transparency obligations apply, the system should be designed so as to address the required AI interaction disclosures, content labeling capabilities, and so on. And the main reason is that these requirements are often design requirements embedded in the architecture and the user experience, and are thus harder to retrofit at the end. So, in sum, the purpose of this step is to bring the system by design closer to exploitation readiness from an AI Act perspective. So, step 6. Step 6 is all about embedding robust risk management throughout the project lifecycle. The main point here is that risk management is not a one-off exercise, but rather a continuous activity. As we have seen, for high-risk AI, this is a legal requirement. But even where the system is not high-risk, the same logic is valuable as good practice. So, the first point I want to make is that projects must analyze and mitigate risks in a systematic and continuous way, spanning the whole design, development, testing, and piloting life cycle. Now, without going into the details, one should ask at each stage, what risks may arise to safety, fundamental rights, privacy, fairness, or reliability? What mitigation measures are in place? Who owns the risks? What evidence is kept? Again, the goal here is to embed risk management throughout the project lifecycle. And the second point I want to make here, as we have already indicated, is that pilots represent an important governance trigger. The reason is that they often go beyond internal testing, moving closer to real-world testing in AI Act terms. So, before piloting, projects should always check whether planned activities have crossed that threshold. If they have, additional safeguards may be needed to comply, such as a testing plan, informed consent where applicable, registration, oversight, and even potentially the possibility to suspend testing if risks emerge. Finally, and with this I conclude, step 7 is about maintaining proportionate and structured documentation from day one. So, documentation is a major requirement under the Act. As we have seen, to comply, providers of high-risk AI must prepare extensive technical documentation, both for authorities and for deployers, covering things such as the intended purpose, the data sources, validation methods, risk assessments, human oversight, and performance evaluations. And they must also provide clear instructions of use to deployers. At the same time, providers of general-purpose AI models must also provide adequate documentation to downstream actors, as well as a summary of the training data used. So, undoubtedly, documentation represents a big part of the overall AI Act compliance burden. Now, in the context of EU projects, the point is not to produce full market-entry documentation from day one. The point is rather to build an evidence trail that is proportionate to the project stage, the maturity of the system, and the level of risk. Even if you are not building a high-risk AI system, or the Act may not get applied, treating documentation with rigor and in line with the Act's requirements establishes good governance. So, adequate documentation can serve at least two main functions. First, it supports reliable system design by making choices, risks, and safeguards explicit. And second, it supports overall compliance, for example, by providing the basis for risk management, for conformity assessments, if this is going to be relevant, and potentially even allowing regulatory audits or ethics reviews. So, a final point before we wrap this up. For EU projects, this documentation should not sit in isolation. Where possible, it should be linked to existing project tools and artifacts, such as the data management plan, DPIAs, where relevant, ALTAI, or other trustworthy AI assessments, pilot protocols, testing and validation reports, and AI-related technical deliverables. So, the takeaway message is that documentation should be treated as a living governance record. It should evolve with the system, not having to be reconstructed at the end of the project when it is disconnected from the actual development process. Strong documentation is a hallmark of AI governance and is increasingly expected by regulators and reviewers. And with this, I conclude this presentation. Thank you again for your attention. Over to you, Christiana.
Thank you very much, Nico, for all these good practices. And because we need to control a bit time, I proceed directly to the next presentation with Giovanna again, and the intersection between GDPR and the AI Act as regards data governance.
Okay, hello again, everyone. In this next session, we will focus on the interplay between the AI Act and data protection regulation. We'll begin by exploring the interplay with the AI Act and data protection law, with a particular focus on the General Data Protection Regulation, or the GDPR. We will see when, in the context of AI development and deployment, the GDPR will need to be observed. And we will briefly see some of the challenges posed by AI to the traditional data protection framework. Then we will focus on the data and data governance requirements laid out in Article 10 of the AI Act. So as we all know, many AI applications process personal data, particularly those that are based on machine learning techniques. And in the context of AI, personal data, which is data, according to the GDPR, data referring to an identified or identifiable natural person, can be processed during the training stage, being included in the data sets that are used to train, to test, or to validate AI. Or these models can then be applied to personal data in order.
Giovanna, sorry to interrupt you, but I noticed that your camera is off.
Oh, that's weird. It says that it's on for me. I will turn it on and off again. Can you see me now? Okay. So yeah, so they can be used for the training of AI systems, but they can also be used then to make inferences about particular individuals. So these inferences, as we all know, can have detrimental effects, for example, by being biased or by simply being inaccurate. And these were all risks that were taken into account by the European Commission when they were drafting the AI Act. So in fact, recital 10 of the AI Act actually explains that the Act doesn't seek to affect the application of the existing EU regulatory framework relating to personal data protection. Instead, providers and deployers of AI systems will continue to have to observe their obligations as data controllers and processors whenever the design, development, or use of their AI system actually involves processing personal data. This recital also clarifies that data subjects continue to enjoy their rights and their guarantees that are awarded to them by existing data protection legislation, again, mainly the GDPR. So data subjects can still exercise their right, for instance, to access and to rectification, as well as their right not to be subjected to solely automated decision-making. And on the same note, recital 63 then explains that the AI Act does not provide a new legal ground for the processing of personal data, and that controllers still need to rely on one of the lawful bases listed in the GDPR, such as consent, legitimate interest, performance of a contract, and others. They need to rely on a lawful basis listed on the GDPR in order to lawfully process personal data. So mere compliance with the AI Act, particularly with the high-risk provisions, does not entail automatic compliance with the GDPR. And this is made clear already in Article 2, Paragraph 7 of the AI Act. But it's important also to point out that not every use of AI will trigger the application of data protection law. This will only happen when personal data is effectively processed. And here we should remember that processing includes virtually every operation that is done with personal data, including, for instance, just storing personal data. And in order to understand when the data protection regulation will actually be triggered in the context of AI, developers should consider whether they are at the collection stage actually collecting personal data, whether they're then using personal data to train, to test, or to validate a model, and finally, whether they are imputing or inferring personal data by the model. Whenever processing of personal data is happening, then the GDPR or other relevant data protection regulations, such as the Law Enforcement Directive, for instance, will then apply. This means that, for example, the principles governing personal data processing will then need to be observed. But there are some challenges that are inherent to the nature of AI and AI development that make this challenging. So, for instance, when it comes to the principle of lawfulness, it is not always clear which is the appropriate legal basis for processing personal data in order to train an AI system, especially when we're talking about large-scale processing or, for instance, techniques that rely on web scraping. Large-scale processing also presents a challenge to the principle of data minimization, since techniques like machine learning actually require vast amounts of data to actually work. And another challenge, to give an example, is that of actually complying with the principle of transparency, since many AI systems sometimes end up operating as a black box. But despite these challenges, whenever there is processing of personal data involved, the GDPR will need to be observed. And as was mentioned earlier today, we're increasingly seeing some data protection authorities actually taking action against AI developers for GDPR violations. So moving on, the AI Act also introduces in Article 10 certain requirements that providers of high-risk AI systems need to observe relating to data and data governance. It states that high-risk AI systems which make use of techniques involving the training of AI models with data shall be developed on the basis of training, validation, and testing datasets that meet the criteria that is then laid out in paragraphs 2 to 5. So first, paragraph 2 states that training, validation, and testing datasets must be subjected to data governance and data management practices that are actually appropriated to the intended purpose of the high-risk AI system. So this practice should take into account the relevant design choices, the data collection process, and the origin of the data. So in the case of personal data, this will also include what was the original purpose of the collection of that personal data, the relevant data preparation processing operations, such as annotation, labeling, or aggregation, the formulation of assumptions, any type of assumptions, the availability, quantity, and suitability of the data sets, what are the possible biases and the appropriate measures to detect, prevent, and mitigate these biases. And finally, any relevant data gaps or shortcomings that can actually lead to a violation of the AI Act. Paragraph 3 then goes on to lay out the requirements relating to the quality of the data. So in particular, training, validation, and testing data sets must be relevant, sufficiently representative, and to the best extent possible, free of errors and complete. This assessment is done again in relation to the intended purpose of the system. And while paragraph 3 actually deals with the notion of data quality, paragraph 4 then determines that data sets should also be relevant,
taking in account the specific geographical, contextual, behavioral, or functional setting where the high-risk AI system will be developed. And finally, paragraph 5 creates a so-called debiasing exception, allowing providers of high-risk AI systems to exceptionally process special categories of personal data when that is strictly necessary for the purpose of ensuring bias detection and bias correction. So, under the GDPR, the processing of special categories of personal data, so for example, health data or data relating to race, is generally prohibited unless one of the exceptions that are listed in Article 9 is present. So, for instance, if the data subject has explicitly consented to that processing. So, what this paragraph 5 of the Article 10 of the AI Act actually does is to create another exception under which AI providers may process special categories of personal data when that data is absolutely necessary to debias their AI systems. There are some very specific conditions that will need to be met for such processing to actually be allowed. So first, the bias detection and correction must not be effectively fulfilled by other means, such as the processing of anonymized data or synthetic data. Second, the sensitive data must undergo some technical measures which aim to limit the possibility of it being reused for other purposes. And these measures may include privacy-preserving techniques like pseudonymization. Third, there must be appropriate safeguards put in place to ensure that sensitive data is actually secured and protected. This can include, for example, strict controls and documentation of access, with only authorized personnel on a need-to-know basis actually being able to access this type of data. And of course, special categories of data must not actually be transmitted, transferred, or accessed by third parties, and they must be deleted as soon as the bias has been corrected or their retention period is over. And finally, as with any other processing activity involving personal data, and particularly sensitive personal data, there must be a record for accountability purposes. So in this case, the record should include also the reasons why the processing of these special categories of personal data was strictly necessary for debiasing purposes, and why this debiasing could not actually be done by processing other types of data, again, anonymized data or synthetic data sets. Thank you very much.
Thank you very much, Giovanna. You have highlighted successfully this very interesting intersection between the two different measures. And we are now proceeding to yet another interplay between two measures, the AI Act, of course, and the Cyber Resilience Act, with Argyro Hartopoulou. I'm sure she's ready to enlighten us. Argyro, the floor is yours.
Thank you very much. It's nice to see you again and to be in this lovely company. We are going to continue from the interplay from with the GDPR to another regulation of the European Union, and this is the CRA, so the Cyber Resilience Act. So it's not as known yet, I will add the yet, part as the GDPR, but hopefully as time goes by, people will get to know it more and realize the good things that it brings, as well a little bit with the burden that it imposes to the organizations that fall within the scope. So let's start a little bit with comparison. So how does these two legislative documents actually have what they have in common? So from one side, in the AI Act, as part of the requirements, one of the requirements is that high-risk AI systems shall be designed and developed in such a way that would allow them to achieve an appropriate level of accuracy, robustness, and cybersecurity. So that actually means that any AI system that is developed, it should be able to withstand specific attacks that come from cybersecurity. And on the other hand, we have the Cyber Resilience Act, the CRA, and it has specific requirements that relate to product to digital elements. And what it says is that product to digital elements have to abide to specific essential cybersecurity requirements. So here is where we draw the line between the connecting line between the one act and the other. So both of them talk about imposing and fulfilling cybersecurity requirements. What we need to see now is what is the relationship between the AI systems and high-risk AI systems with product with digital elements, which is the key operative word of the CRA. So a product with digital elements is anything that has the ability to have a connectivity. So it could be a software, it could be a hardware, and it could be even a remote data processing solution that has this ability to connect and perform a specific activity. So within the software, of course, we can think of any type of software. It could be a mobile, a gaming app. It could be an accounting software. It could be something that facilitates work for a business. It could be something that we use in our everyday lives. And the same goes for hardware. It could be our smartphones, our laptops, the home cameras that we have, smartwatches, connected toys, but also things that we can find in more professional and business-related environments, like modems or firewalls or smart meters or anything that is used within a business or an industrial environment. So anything that is classified under these categories or can be described in this way could be a product with digital elements. And because I know it's a bit late, I think I'm at the last point of this presentation. So to make it a little bit more practical, I have prepared a little bit of a Slido. So the question is very simple. So we have an AI system for assessing and determining whether a person should be admitted in an educational and vocational institution. I think you saw a relevant example like this in the presentation of Christina. So considering this, please answer the question, how would we classify this specific product? In order to answer the question, you just need to go to the Slido.com and put this ID that is shown here, or you can scan the QR code from your screen and go directly to this link. And by doing that, we will be able to see what you believe regarding this product. As I said, it's an AI system that has the ability to manage and provide information regarding the access and admission of a person within an academic or a vocational environment, institution. So I don't know if, yeah. Some have started to participate. That's great. Thank you. I was despairing a bit that nobody would see the Slido. So the main answers here is that whether this is an AI system or not, whether this is a high-risk AI system, and whether it needs to comply with the AI Act, or it is a product with digital elements and it needs to comply to the CRA, or that it is both, or that it is none of the above. And I see that the 6 people have already replied, and the replies are, wow, equally distributed between the answers. We have now a little bit more. So I know that the clock is ticking and I don't want to take too much of your time, but this is the kind of answer that we should be able to reply to after we finish this part of the presentation. So first of all, I think I gave the answer pretty much when I was describing the use case, is that it is an AI system. And taking what was written in Annex 3 of the AI Act, it's a high-risk AI system because it determines by itself whether a person should be admitted to an institution, an academic and a vocational institution. So yes, of course, it's a high-risk AI system and it needs to comply to the AI Act. So taking the definition that I provided regarding product with digital elements, so it is either a software or hardware. Yes, it's a software. It has the ability to connect and perform specific activities. Then that means that it is a product with digital elements. So since it's a product with digital elements, it has to comply also with the CRA. So that there should be a tick there. So AI system, high risk, product with digital elements, and it should comply to the CRA. So what happens when we have a product that is in both cases? So it's in the CRA, within the scope of the CRA, and within the scope of the AI Act. Then it's simple. It has to comply to both. This provision has already been made both in the AI Act and the CRA, although they were published at different timelines. Whenever we have a product that fulfills both, that falls within the scope of both, it has to fulfill the requirements of both within the scope and the lens of each one. So what it means, actually, what I'm trying to say is that there are these requirements regarding cybersecurity within the AI Act. I showed you in the first slide, and we have an entire regulation, which is the CRA, that talks about cybersecurity requirements of product with digital elements. So what it says, the AI Act, is that, and the CRA, is that you can use the CRA in order to fulfill the requirements regarding cybersecurity of the AI Act. And if we have a product that has been checked and fulfills the essential requirements, the cybersecurity requirements of the CRA, then that means that it actually fulfills the requirements, the cybersecurity requirements in Article 15 of the AI Act. So there's a lot of wording within the rationale of the AI Act on this and the CRA on this. And I have put only a snip of this, and there are different cases, but that's the main gist that you are supposed to get out of this. So if we have a product with digital elements, then that it needs to fulfill these requirements, and it needs to also, either at the level of conformity assessment on the first degree, so self-assessment, or in third-party assessment, it needs to prove that it fulfills these requirements. And there are a lot of other things within the CRA, and the first one of them is that the CRA differentiates between, it classifies products. It actually splits products into critical products, important products, and products with digital elements that belong to the default category. And depending on this classification, based on the core functionality of the product, then we have different requirements. Not different requirements in terms of essential requirements. These are the same for everything, but we have different requirements regarding how to prove that you fulfill the essential requirements. And here you can see in this very simple table, how different types of different classes of products that as they are recognized within the CRA have to go through different types of conformity assessment. So the first one is the internal control procedure that we already mentioned in the previous presentations on conformity assessment, and this is the self-assessment, which is allowed only in the default category. So an AI provider does not only have to fulfill the requirements of the AI Act for the AI system, but the AI provider has to check which is the category of the CRA that this product belongs to and fulfill the essential requirements, cybersecurity requirements that the CRA says, and go through the conformity assessment process that is prescribed by the CRA in order to prove that they fulfill these requirements. In order to have a little bit of an idea of what the classification is about and what are the rules to classify the products within the different categories of the CRA, I have put here some examples. For example, an important product that belongs to class 1 would be the browser that you're using right now in order to participate in this meeting. So this is considered to be an important product. So it is not in the default category. Whereas a product like a hardware device with a security box is a critical product. And an important product that belongs to class 2 would be a firewall. Everything else that doesn't belong not on this, this is just a snip, but in the lists that are included in Annex 1, in Annex 2 and Annex 3 of the CRA, everything else is considered a product that belongs to the default category, and in this case, we can have self-assessment based on the CRA. So the reason why you can see this scheme, this figure where we have the iceberg, is that the estimates are that a huge percentage of the products with digital elements will belong to the default category and will not comply to the essential requirements, but the activities regarding conformity assessment will be on the simpler side. And I see that the time is really, really fast going by. So I will just say very quickly what are the main requirements that and the flow of activities that need to be implemented by a manufacturer based on the CRA. First of all, they need to start with the risk assessment, and this is a very strong. There's a very strong similarity to what Nikos was presenting before about the steps that need to be implemented also for AI Act compliance. So we need to have a risk assessment. There needs to be a compliance against the requirements. There needs to be some vulnerability, the management of vulnerabilities, not only before the product is released, since one of the essential requirements is that no vulnerabilities should exist, but also during the lifetime of the product. Conformity assessment processes should be implemented, and then after it's released to the market, it has to go and there has to be a monitoring and an update and a support regarding vulnerabilities, regarding incidents, and about the robustness of the product throughout its maintenance period. So all these obligations have to be fulfilled. There is a timeline, of course, for the implementation of the CRA. The first obligations come into effect on the 11th of September of 2026. We will have obligatory reporting of incidents and other issues from the manufacturers with different timelines regarding early warning and a full notification. And we have the full application of the Cyber Resilience Act in December 11th of 2027. So as you saw in the beginning, I represent also a project that is called Curium. It's a European funded project that aims to create and support organizations in the compliance to the CRA. So there is a number of tools that have been created and are provided free of charge to anybody that is interested. Starting from a tool that would allow you to see whether you fall within the scope of the CRA, because there are specific rules in alignment with what Christina said about the classification under the AI Act. Then you get to do the risk assessment, you get to have a tool that will show you different options regarding risk treatment. You have different tools to test whether you have vulnerabilities or whether your product is robust. And then you have a product that would allow you to check the documentation that you have created to whether it fulfills the requirement of the CRA. All of these are provided by the Curium project, and you are most welcome to join us by declaring your interest here. So you can see this QR code and you can see this EU survey link where you can declare whether you're interested in using the tools, and we can provide them free of charge, and of course, and we provide also additional training and consulting in order for you to use them for your own products. So that was it. I'm sorry if I took a little bit more time, and thank you very much.
Thank you very much, Argyro. I like very much your slides. So everybody, that was the end of the part B, and thank you all for being with us till now. We can get questions if you have any, but also bear in mind that if you have something that you need to ask and you didn't have the chance to do it today, or you didn't feel like doing it today, you are welcome. You can send it by email, and we make sure that you will receive an answer. I will start with a question for each speaker, and I will request our presenters to be very quick and brief so that it doesn't take long. Starting from Nikos. Your presentation, Nikos, was full of questions and things that the AI operators will need to take care of and obligations to comply with. It appears that the compliance is quite complicated. Isn't this too much red tape? What do you think that the AI Act will do for innovation and research?
Okay, so thank you, Christiana, and thank you for this indeed very relevant and very timely question. In fact, the co-legislators, that is the European Parliament and the Council of the EU, are currently under the so-called trilogue negotiations to try to determine and decide on whether they will adopt and to what extent the digital omnibus by the European Commission, which is essentially an attempt to simplify and streamline compliance with digital rules, affecting both the GDPR and indeed the AI Act. So yeah, overregulation is a real concern at the moment, and the geopolitical tension is very high. With regards to whether the Act is too much of a red tape, just a couple of points from my side. First, as we saw, the Act itself includes a number of pro-innovation rules and mechanisms. Right. So compliance for startups and SMEs is simplified, and it also foresees regulatory sandboxes where essentially companies can experiment hand in hand with the regulator, receiving real-time guidance on how to navigate complex issues. Point number two, what's the alternative here? Is it no regulation at all? I think not, given how disruptive this technology is. Or is it no uniform or no horizontal regulation? I mean, again, let's take the US approach. At the federal level, we see no regulation at all. At the state level, we see a number of fragmented initiatives. So a company that wants to do business there, instead of having to comply with one uniform legal framework, will have to navigate, I don't know, dozens or maybe hundreds of state-level initiatives and sector-specific laws. So this seems to be a much worse situation, right? And although the Act is not perfect, that is for sure, I think it is reasonable in asking for some risk management and quality management process in the context of developing and deploying AI systems. And a third point, and with this I conclude, although it is true that compliance with the AI Act will require significant resources, undeniably, I believe that this eventually will end up to be a competitive advantage for companies that do comply with the AI Act, much like we saw with the GDPR, right? So when I want to do some newsletter management, I need some assurance before I contract with a vendor. Likewise, I think that deployers will push providers to demonstrate compliance with the AI Act and trustworthy AI systems. So to wrap this up, the Act will certainly require the legal and technical departments to sit at the same table. I think this is a good thing if we also care about the ethical and the societal implications. Now, whether it's too much of a red tape remains to be seen in practice, right? But note, and with this I close, there is real room in the way that the Act will be implemented and enforced to steer it either way. So yeah, this is a very good question. This is all from my side. Thank you for this. Thank you for this.
You are very right, Nico. The legislator strives to strike a balance. Now, Christina, you talk about exceptions from the AI Act, the way out from this very demanding system. There is an exception regarding open source system software, but I'm wondering, what if an open source system is a high-risk one, which we know high risk means risks to the health, safety, fundamental rights. What do you have to say about that? Does the exception apply in that case as well?
So thank you for the question, because this was not covered in my earlier presentation. Indeed, most regulations in the EU try to promote open source. So a very welcoming exception from the application of the AI Act was the exemption regarding open source. I think it's Article 2, Paragraph 12. But before answering the questions, we have to see through the Act what is actually considered open source. So you have to have in mind the definition that your open source license is one that grants your users with, let's say, unrestricted rights to access, to use, to modify, and to redistribute without payment. And this is very, very important there, that you have to do this without payment. So if you fall into this category, first of all, you have the benefit of the exclusion that the Act gives you, not that it doesn't apply to you. And this is because Europe tries very much to strengthen open source communities. But there is truly, the answer to your question is yes. First of all, if it is a prohibited AI application, we don't have a discussion, like it's prohibited. But also, if it falls, if you do, after you check that is your open source falls under the definition of open source, then you also have to go through the high risk check, because high risk AI system cannot be unregulated. So if you do follow the two-step check and find out that this open source is high risk, and you are the person that, for example, modifies and distributes, incorporates it into its own product, then yes, you have to abide by the high risk requirements. That is the answer.
I think it makes perfect sense, Christina. Thank you very much. Now to Giovanna. As people striving to help organizations comply with the GDPR, I have a question for you, Giovanna, very practical. What is the appropriate legal basis for processing personal data in order to train AI models?
Yeah, the appropriate legal basis, so to speak, still very contested topic at the beginning when these models first emerged. There was a discussion about whether or not these companies could rely, for instance, on the performance of a contract, but the Italian Garante said no, it does not fulfill the requirements to actually be the appropriate legal basis, and that left companies with either legitimate interest or consent. Consent proves to be very challenging, even though it is the most appropriate, in my opinion. But it's challenging because we're talking about requiring consent of a very, very, very large number of people, and that is not always feasible. Whereas legitimate interest could be used, but a lot of times might fail the balancing test, especially when we think about what are the reasonable expectations that the data subject actually has. But to give a spoiler, Nikos already mentioned that there are discussions on the digital omnibus. It wasn't voted today, but one possibility of actually altering the GDPR that is in the omnibus is to actually recognize legitimate interest as the legal basis for this type of training of AI systems. So if it is approved, then a lot of uncertainty in this regard will be solved, even though may not be the most appropriate choice.
Yes, thank you very much, Giovanna. It is very important to have certainty in this area, especially we all know if we take the legal basis wrong, this is a very serious violation of the GDPR. So, in my opinion, at least, official bodies should make sure that there should not be any uncertainty with regards to such central legal obligations. But I also thought that consent would be impractical, and I was leaning towards the legitimate interest with its pros and cons, of course. And finally, to Argyro. So, Argyro, regarding your first presentation, will the National Supervisory Authority notify me regarding my obligations based on the AI Act? Shall I rest assured that I will receive a notification?
Right. So the obvious answer is no. It is, we should all be trying to get as much information as possible. And because there is nobody going to come knocking at our doors and tell us that, you have an AI system and it needs to comply to the AI Act. So let me just come and help you and notify you. Of course, that's not going to happen. This is why these events and all our activities that relate to the compliance to not only to the AI Act, but the CRA that I showed in the second part is really, really important. And I see a very similar, maybe an adjacent question in the chat, if I may answer that at the same time.
Of course you can.
It says that whether the EU member countries are ready in terms of infrastructure, but I'm guessing not only infrastructure, to implement checks for compliance. And that goes not just for the AI Act, but the CRA. And the answer again is no. Easy, simple answer. It has a lot of details, this discussion regarding the readiness of the member states. I showed you for the AI Act, for example, that we currently do not have yet a notified body, even one in the European Union, that would be able to check for the requirements of the AI Act under Annex 7. That is also due to the fact that we do not yet have all the necessary standards. So as I showed you in the slide, we are still in the process of creating the first harmonized standards that are needed. So if you don't have the harmonized standards, then it becomes a little bit more difficult to make sure that you fulfill the requirements, since you don't have the guidance or the requirements in hand. And conformity assessment, when it comes to third-party assessment, is really based on standards. So if you don't have the requirements against that which they have to check, you, then it's really difficult to have that. So we are not ready, and it says how long will it take? So I'm going to be the optimistic, and I would say that it will be done in 2027, but it remains to be seen.
So thank you very much, Argyro, for this comprehensive answer to the last question. Everybody, a big thank you to, first and foremost, to our presenters. You really did a wonderful job. And of course, our thanks to our audience, especially those who stayed till the end with us. And we're very happy to see this participation, intense participation, high numbers, and we really hope that we manage to give you sufficient information and knowledge regarding admittedly technical legislation and more generally requirements. As said before, if you have any question that you didn't get the chance to pose, please don't think twice, just drop us a line and we will make sure that you receive an answer. So everybody, thank you all. Have a nice afternoon. Bye-bye.
Thank you. Bye-bye, everybody.
Thank you, everybody.
Thank you. Bye.